Good morning to everyone. I'm District Attorney Tom Quinn. I would like to welcome everyone to the Bristol County Dangerousness Survivor Roundtable. A special thank you to UMass Law for hosting this important event, and a special thanks to Governor Baker and Lieutenant Governor Polito for being here and continuing to advocate for public safety reforms of the dangerousness statute. Like the Governor and Lieutenant Governor, public safety and the safety of victims in our communities has been a top priority of mine as District Attorney. The most dangerous criminals should be held without bail pending the outcome of their criminal cases. People have a right to feel safe in their communities. Unfortunately, due to the current language of the dangerousness statute, prosecutors are prevented from moving for dangerousness hearings in many cases because the statute does not include certain offenses. In particular, the statute must be amended to add sexual crimes against children and other offenses that endanger individuals and the public. One of the offenses enumerated in the governor's bill as a dangerousness offense is the distribution of child pornography. This is an offense that must be added to the dangerousness statute. My office previously prosecuted a level 3 sex offender with a significant criminal history of sexual offenses, who was charged with possession and distribution of child pornography that included pornographic images of infants and toddlers being sexually assaulted. This defendant also disseminated child pornography that contained images of children 7 to 9 years old engaged in sex acts. Under the current law, we could not at that time move to detain the defendant as a danger. The Superior Court judge and prosecutor were limited to the traditional bail considerations that did not include dangerousness. Obviously, this individual posed a threat to children based on his history and the crime. Bail was set at $20,000 with conditions, but this defendant should not have had the opportunity to post cash bail. The judge expressed frustration at being limited to bail in this case. It's really a horrifying example that demonstrates the need for change to the statute. Fortunately, we collaborated with the U.S. Attorney's Office. The person was indicted and received a substantial sentence. Another example is aggravated rape of a child by age difference. The Supreme Judicial Court in the Sion case ruled that aggravated rape by age is not a crime that is covered by the dangerousness statute because force is not required. A 50-year-old could have relations with a 7-year-old repeatedly with a bad record. You cannot move to detain that person and are limited to cash bail. In his concurring opinion, Justice Lowney asked the legislature to continue amending the statute, and I believe I was with the governor either that morning or right around the time that this decision was passed in a gathering about the dangerousness hearing. I agree with Justice Lowney and the governor that the pretrial detention statute must include sexual crimes against children, regardless of whether force is used to commit the crime against child. At the time of this decision, we had 4 defendants in Bristol County charged with this offense, aggravated rape of a child by difference of age, who had been found to be dangerous by the court and held without bail, but were released after this decision came down. We cannot continue to have these dangerous defendants be released back into the communities without the opportunity to request them being detained for that very serious crime. The governor's bill would add offenses to the current dangerousness statute to include dangerous criminals who victimize children, so I thank you for that. In addition, in those cases we can currently move to detain a person as a danger, the statute does not provide an adequate time frame to prosecute the defendant. This results in dangerous defendants being released to the streets with the opportunity to commit additional crimes before their trials occur. The statute should be amended to be consistent with the current Rule 36, which states that defendants must be brought to trial within 1 year, which the governor's bill provides for. A dangerous defendant does not become less dangerous with a passage of 180 days or 120 days, which is the current time frame in both courts in which someone can be held. I actually was able to get it changed slightly in the Superior Court, where the more serious crimes are prosecuted from 120 to 180, but that is not enough time. This also should apply to bail revocation proceedings where a defendant commits a new crime while on release from a previous offense. We are currently prosecuting a defendant for trafficking in both heroin and cocaine. The defendant was found to be a danger in the Superior Court and held without bail. The defendant was released after the expiration of 180 days. While on release, he was arrested and charged in Brockton Superior Court with trafficking in cocaine. This illustrates the need to reform the time frame to 1 year, consistent with the existing rules of court. The pretrial detention statute is the best way to keep dangerous defendants in custody while they await trial. The governor's proposed changes to the dangerousness statute do not impact the defendant's due process rights. They simply make it fairer for victims, society, and the administration of justice. The proposed amendments to the statute make it more equitable by focusing on the facts of the case and the defendant's prior criminal history in determining someone's dangerousness. The real question is, should a person be held or not held, not how much money they can afford to spend on bail. I again would like to thank the governor and lieutenant governor for holding this event here today and also appearing throughout the state in similar roundtables to advocate for these important changes. I would now like to introduce Secretary Reidy from the Executive Office of Public Safety to say a few words.
Thank you, DA Quinn. Good morning, everyone. My name is Terrence Reidy. I'm the Secretary of Public Safety. I want to thank UMass Law for hosting us and DA Quinn and his team for hosting us today. This is our 5th roundtable. We've had roundtables in Plymouth, Springfield, Worcester, Salem, and now here in Bristol County. In my prior experience before becoming secretary, I was a prosecutor for close to 20 years. And after our first roundtable in Plymouth, I spoke to the governor and the lieutenant governor. And I handled a lot of serious cases, murder cases, gang cases when I was a DA. And I've had a lot of brave victims and witnesses and other survivors work on cases with me. And my experience in Plymouth, when I mentioned this to the governor and lieutenant governor, is the same for every county that we've had these roundtables. Is the bravery and the courage of the survivors who have come forward to support this legislation and talk in public about the worst days of their lives and the continuing trauma has been amazing. It's just bravery and courage. DA Quinn talked about some of the loopholes in the current 58A statute. The major concerns we have, and there's a lot of really good aspects to the governor's bill, but the main concerns that we have, and that's been reiterated at these roundtables with survivors, is charges not inside of the current 58A statute. Charges like certain firearm offenses, indecent assault and battery on children, assault and battery on disabled individuals, statutory rape. Major crimes with people who commit those crimes are dangerous to the community. Dangerous to the community, dangerous to their survivors, and dangerous to their survivors' families and friends. The other main concern we have is the duration of being detained, as DA Quinn indicated. You don't all of a sudden become less dangerous because you're held for a certain amount of time. These offenders, after a full hearing, and again, just want to highlight, this isn't the police department or the DA's office saying, I want this person held, and they're held. It goes before a judge, there's a full hearing, they're represented by counsel, and their due process rights are adhered to. But there are certain individuals in this state that shouldn't be on the street, and that's what this bill focuses on. The other main concern is looking at someone's record of convictions, not allegations, record of convictions. And if you're convicted of a crime in this state and you pick up another offense that may be outside of the 58A statute, you're still dangerous. The DA's office should have an opportunity to make their case in front of a judge to determine who should be held and who shouldn't be held. Again, in front of a judge, represented by counsel, with their due process rights protected. When I was a prosecutor, I had a case in Worcester with a member of the Sovereign Citizens Movement, a white supremacist hate group. That individual had about 3,000 rounds of ammunition in his vehicle. He had, I believe it was about 4 or 5 large capacity magazines, but he didn't have a firearm. It wasn't in the car when he was stopped by the Worcester Police Department. I couldn't move for a dangerousness hearing. Because under the current 58A statute, there has to be a firearm, the magazine has to be inside the firearm. So we had to argue traditional bail. I think it's a hard argument to make that that individual wasn't dangerous. It should have been held under a 58A hearing, but we couldn't do it. That's a loophole. These roundtables, with the survivor's bravery, highlight loopholes in this law. They step forward to put a face to these loopholes. And you're going to hear traumatic stories from our survivors today and statements from survivors that are going to be read. And what's really important about that, especially with the statements that are being read, it's going to highlight the trauma and the fear that those individuals have. I know we have 2 survivors here in person. Thank you so much for being here. This day is really about you two stepping up and coming forward. And what I've brought up in the last 4 roundtables was a statement that one of the survivors made at the first roundtable in Plymouth. And this has stuck with me, and I know it's stuck with the governor and the lieutenant governor. It's a basic human right to feel safe. As a person, as a family member, and as a community. And that's what this legislation is about. And with that, I'd like to turn it over to Governor Baker and Lieutenant Governor Polito. Thank you all.
Thanks, Mr. Secretary, and DA, thank you for your support here, and much appreciation to MOVA and to your organization for all the work you've done in this space, Liam, and to the 2 folks who are going to speak today and to those who are submitting statements, I just want to say this is really about you, and we very much appreciate your being with us, and I'm sure that the opportunity to speak for you is a challenging one because it forces you to relive something you would prefer not to. And I just have to say that Secretary Reidy's comment about putting a person and attaching a person to these issues and these circumstances is incredibly important in convincing others that there's a problem here that needs to be fixed. And the final thing I'll say, because the DA and the Secretary have pretty much said it all, is the comment that was made at the Plymouth Roundtable that has stuck with me throughout the course of these discussions is one woman who said, I really didn't feel like the state was on my side. And we should never be in that position. And I'm sorry that we've been in that position for many of you and for many like you. But again, I really appreciate you being here today.
Thank you, Governor. Thank you, Secretary Reidy. Thank you, Liam, Lowney, and all of you at MOVA for what you do every day. I want to thank the team of people who are here, DA Quinn and Jen Sauer. I want to thank Courtney Cahill, Laurie Myers at SORB. Thank you all for your incredible work here in Bristol County. I want to thank you, DA. You've been a great friend to our administration, but also to survivors and victims and to justice and to law enforcement here in the county. Courtney, you've been an incredible player in the Sexual Assault and Domestic Violence Council of the Governor's Office. I want to thank you personally for your co-chairing the Assessment and Response Committee. You've done an incredible job providing more tools to prosecutors to be able to have the evidence and information to work within the courts to hold perpetrators accountable. You've also worked very closely with law enforcement to give them the assessment tools, the strangulation tools, and develop a better response at the doorstep when a victim calls and needs help, and also the warm handoff to the provider groups to give victims and families the support that they need. You're doing all of that here in Bristol County so well, and we appreciate that. But we all know that there are problems, and the system hasn't performed in the way it should for victims and survivors of domestic violence, sexual assault, and horrific crimes that we are obviously highlighting today. And this is what the process is supposed to be like. You got Representative Markey here also a lawyer representing, his interest in the legislative branch. You have the executive branch here, you have the judicial branch. And when the system doesn't work the way it should, it's incumbent on all of us to work together to figure out what the solutions are and move forward and get that done. We have 2 law students here who are graduating in another year, studying to be prosecutors and figuring out how they can work in the system and do a better job. But in this case, we have worked through criminal justice reform. We have worked through bail reform. And now this is an opportunity to reform the dangerousness statute so that we are up to date and provide the prosecutors and the team of people who work in this space the tools that they need. When bail reform was done, the idea that you could post or have a high bail to hold someone for dangerousness was removed. When that happened, I believe an unintended consequence is the problem that we have with our dangerousness statute. You heard the DA articulate the various loopholes or gaps. You heard Secretary Reidy explain when he was a prosecutor how cases didn't fall squarely into the statute and left people like you in a very, very vulnerable place. What we're doing today is asking you to do something that's very difficult, to come forward and to relive in a public forum the circumstances where the system failed you. These are very difficult, very painful, and very hard circumstances that you lived through. And we appreciate your being here today to articulate the reasons why we cannot waste another minute in passing these reforms, closing these gaps, and changing the Massachusetts laws relative to dangerousness and the opportunities that we can bring forward. I also want to just highlight that you are speaking not only about your own circumstances, but there are unfortunately many others who have suffered at the hands of a violent perpetrator or trafficker or someone that has very aggressively offended them. And some people don't have the ability to come forward and share their stories, and some of these people haven't even gone into the process to hold their perpetrator accountable. So I want to thank you for coming forward, for your strength to not only highlight your situation, but for making it better for others and for many people, unfortunately, in the future that will find themselves in harm's way. Back to Secretary Reidy, it's about leveling a playing field. It's about making Massachusetts safer for everyone and making sure that we, as part of this system, are doing our jobs to better protect you. Thank you very much for being here.
Thank you, Lieutenant Governor. Governor Baker, again, we very much appreciate you coming down here to discuss this very important issue. I would like to now introduce several survivors to give their statements. Again, I want to thank you for coming here, taking the time to come down here, and also having the courage to speak about certainly very bad experiences. So I'd like to first call on Kelsey to speak.
Good morning, everyone.
Good morning.
Dear Governor Baker and Lieutenant Governor Polito, my name is Kelsey. I am 32 years old. I am here to support the bill and act to protect victims of crime from the public. I am a survivor of childhood rape and sexual abuse, and I strongly believe that we, adults, must do anything and everything we possibly can to protect children from sexual predators. Not only was I sexually abused, but the person who abused me also showed me child pornographic videos. I'll never forget that, and it still haunts me to this day. In my case, the abuser was my much older brother's best friend. He was estranged from his family, and we took him in. Our family loved him like a family member. He was a trusted caretaker of me. He fooled us all. He first groomed my parents, then he groomed me. He gave me gifts, was nice to me, took me places. He abused me at home and in public places like parks. He He was never mean or violent towards me. He began sexually abusing me nearly every day, starting at age 5, and it went on for years until I was 13. It was very confusing to me. How could someone so nice to me and seem to care about me have hurt me so badly? I had the hardest time trying to figure it all out. What I learned from my experience is that child predators do not need to use violence or weapons to be successful in raping and sexually abusing children. The age difference and the trusted role an offender plays in a victim's life is power enough. Maybe if my abuser had been violent towards me, it would have made a lot more sense to me. When the abuse first came to light, I was very fragile. We were all scared of what was going to happen. I thought he would go to jail right away and I would be safe. That did not happen. Fearing for my emotional and physical well-being, my parents did not go forward with the case. However, I was so traumatized by the harm perpetrated upon me by the abuser that I ended up psychiatrically hospitalized many times, particularly after suicide attempts. Years later, I was able to go forward with a criminal case. However, the crimes he was charged with were not covered by the Dangerousness law. He was reconnected with his family at that time, and they helped him post a really low bail the judge set, a bail the prosecutor could not appeal. It was terrifying that he was out and free while the case was pending. Because of the continued struggles I faced with my mental health, I agreed to a plea. His sentence did not feel like justice at all, especially because he was released early for good behavior. So he got a slap on the wrist for ruining my life. I feel I was given a life sentence. My life has been plagued by a vicious cycle of anxiety, depression, and suicidal thoughts. I spent more time in locked mental health facilities than he did in prison. I pressed charges for 2 main reasons: to hold him accountable, but more importantly, so no other child could be hurt by him. And as far as dangerousness goes, just because someone isn't outwardly violent doesn't mean they are not dangerous. My abuser is the type of person you'd never suspect of something so horrendous. When it comes to child victims, like I said, the offender does not need to be violent because of the power dynamic between child and adult. When I was really young, I remember my abuser telling me not to say anything or we'd both get in trouble. To a 5-year-old, that could be all it takes. That's all it took in my situation. No child wants to get in trouble. A pedophile could completely destroy a child's entire life without ever being violent, but those type of people are still dangerous. I continue to struggle to this very day. I know the pain, shame, guilt, and the never-ending cycle of anxiety and depression that is left in the wake of sexual abuse. I never had a chance to succeed in life. I never want another child to suffer the way I have. I would like to thank you for proposing legislation which would further protect children and our communities. Too much leniency for sexual predators leaves our children and communities at risk. I hope the legislature hears our voices by passing this dangerousness bill.
Thank you very much, Kelsey. You are succeeding in life just by being here and speaking out, so thank you. Very sorry for what you've had to go through. I'd like to call on Danielle to speak next. Danielle, thank you.
Good morning. Before I share my story, I'd like to thank the governor and the lieutenant governor for filing the Dangerousness bill. This legislation is an important step in closing the gaps in our state law that currently do not provide adequate protection for victims of dangerous persons. Thank you for the opportunity to be here and to share my story and the experiences that are relative to the Dangerousness bill. My name is Danielle Sicard. I'm a mother of 4. I work in local government as a town clerk, and I'm a survivor of domestic violence. 9 years ago on April 4th, my life changed forever when my husband of 20 years attacked me in our home. My story is not like many victims of domestic violence in that prior to this day, My husband had never hit me, and there were no incidents involving the police or courthouse in any way. Our marriage wasn't perfect, and despite 6 years of marriage counseling, I had no idea that I was in an emotionally and sexually abusive relationship. I find that hard to believe now in what I call my post-abusive detox mind, that I didn't realize that a man that could drug and rape me just 6 months before was also capable of trying to kill me. But like most victims of domestic violence, I was at risk when I told him that I wanted a divorce just 3 weeks prior to the worst day of my life. There isn't enough time here to go into all of the details of my attack, so I'm going to give you the highlighted, bulleted version. On this day, my husband entered my room under the pretense of wanting to show me a relaxation technique. Instead, he tried to snap my neck, which led to strangulation, me passing out, him raping me, and him finally letting me go after holding me there for about an hour and a half. My injuries were so severe, for 3 weeks you couldn't see the whites of my eyes as they were filled with blood. I will never forget the feeling of every blood vessel popping in my eyes. My tongue was 3 times its normal size, and I couldn't taste anything for 6 weeks. This is what happens when you're strangled nearly to death. After being at 3 different hospitals that day and into the night, the next day I found myself at a district courthouse looking for a restraining order. I'm so thankful that despite being in shock and still not fully comprehending what happened to me, the people around me understood the severity of my situation. They recognized the danger and the risk that I was still in. But with that reality came the traumatizing experience of having to testify at a dangerousness hearing. In a courtroom filled with strangers, a courtroom filled with his family, people who the day before I considered my family, all in order to fight for my safety, and all of this while my injuries were still very evident. Although my husband was initially found to be dangerous and was held without bail, I was horrified and terrified to learn that the time was limited. The weeks and months that followed involved multiple dangerousness hearings, one in Superior Court in which I was summoned to appear and testify in, and another after the 90 days was coming to an end. Let me tell you, testifying in a dangerousness hearing in front of the person who tried to kill you and a defense attorney who's trying to break you down is no easy task. It was necessary to save my life and my children's lives. This is a traumatizing experience, and I felt like having to do it again and again was like fighting for my life, just like I did the day I was attacked. Each time I was filled with anxiety and fear of what the outcome would be. I cannot express to you the extreme relief that I felt when I learned that the Superior Court upheld the dangerousness status from the district court. During the attack, I had begged for my life, pleading with my husband to take into account that if I should die, he would go to jail and that our kids would be left without any parents. At the time, I was so fearful that my husband would kill me, my children, and himself if given the chance that release would have offered him. Everything I knew to be true in my life changed forever on the day I was attacked. My safety, my financial security, and my understanding of trust and love, everything that my children knew, their entire foundation was cracked. Every hope or dream that I had for my family was ripped out of our lives. This is the reality of domestic violence. Knowing that my abuser was behind bars as a result of the dangerousness hearings allowed me the time to begin healing, to begin the cleaning up the mess of the attack had left for me and my children. And this was a safe time for me, and it gave me the courage that allowed me to move forward as a witness in the criminal process. There are so many pieces of this bill that I think just make sense, and some, quite frankly, I was shocked that they didn't really exist already. Individuals found to be dangerous should be detained until the disposition of the case. A defendant's dangerousness and my safety doesn't diminish upon the expiration of a set number of days. And each and every time I was called to the courtroom, it was like being victimized all over again. If my husband had not been found dangerous in district court, under the current law, the prosecutor would not have been able to appeal this bail. My husband, however, would have had this legal option, but not me as a victim. Yet it's my safety that depended on that. I find it shocking that if my ex-husband were to commit another offense, that prosecutors and judges currently do not have the ability to consider his criminal history in determining if a dangerousness hearing is warranted. Although he has done his time, his actions on that day make it more than possible that he is capable of doing something that puts victims, myself, and the community at risk. The aftermath of a domestic violence situation is a painful and confusing time for victims and their families. And it's compounded with agonizing and traumatic interactions with the court system that provides so many rights for the defendant and not enough rights and compassion for victims. I was so fortunate that a dangerousness hearing was called, but that is not true in far too many cases. How can the prosecutor know all the circumstances and the history by the time of an arraignment after only one incident? Not all victims walk into a court bearing highly visible injuries like I did, but it does not mean the danger is less significant for them. Allowing them to call for a dangerousness hearing beyond the first appearance in court, I think just makes sense. I hope my story highlights some of the items that this bill is trying to accomplish and helps inform lawmakers of the importance of the dangerousness law and how it can save lives. I believe it saved my life and my children's lives, and it's time, I think, that we close these loopholes. I want to thank everyone who's been involved in putting today's event together, to the governor and to the lieutenant governor for having the foresight to spearhead this bill and for providing me with the opportunity to share my story. You have given me and other survivors a voice, and this is so instrumental in our continued journey from transformation of a victim to a survivor. Thank you very much.
I have a question on that. So the 90 days was the first through district court?
So the
90 days, and then was there additional time?
There was three
Or the whole?
dangerousness hearings.
Okay.
So when it went from district court and the case went to Superior Court, another dangerousness hearing occurred. And then another dangerousness hearing at the end of the 90 days as we were approaching the trial date.
I want to thank you for speaking. It is just from a human perspective, and you see a number of these cases, see the brutality involved in some of these cases. It is very sad, but I'm glad that you've moved forward, you're involved with MOVA, and I think you present a very important testimony that a person should be held to the case is resolved unless there's legitimate change circumstances. And from a due process perspective, they could have 3 dangerousness hearings, one in the district court, could appeal, and if they are indicted on the case to Superior Court, a third dangerous hearing. So there are due process protections, so people are not held that shouldn't be held, but thank you very much, Danielle, for your testimony. Next, we're going to hear from Tia, and this is going to be a statement read by Jennifer Soa from my office, Second Assistant District Attorney. Thank you.
Thank you. It's my privilege to relay Tia's story. Tia's story began with her childhood and her parents' relationship. Tia and her sisters witnessed their father's physical and verbal abuse of their mother for many years. He constantly threatened them, he owned a large gun collection, and fear ruled in their home. After her mother filed for divorce, he engaged in the worst kind of parental alienation of Tia. His emotional manipulation and grooming of Tia began to work. She became estranged from her mother and went to live with her father when she was 13 years old. After a short time, her father began raping her. It happened too many times to count, almost daily, and never less than 3 times a week. He was a long-haul driver and often raped Tia at truck stops. He showed her pornographic movies about fathers and teenagers having sex. He dressed in horror costumes and violently raped Tia as he acted out these sickening fantasies. Tia became his replacement wife. He gained her silence by threatening to kill her and himself. Tia's younger sister came to live with them when she was 16. Tia feared that he would start to abuse her, as she was of the age that Tia was when the abuse began. Soon after, another rape of Tia occurred, and she finally could not take it anymore. She called her mother, she went to the police, and then did a rape kit at the hospital. A rape kit in and of itself was a horrifying experience for Tia. The ensuing trial process was terrifying for her and her family. Her father repeatedly violated their restraining orders and his conditions of bail. He relentlessly tried to get Tia to drop the charges, and he had offenses in multiple jurisdictions. He was held on dangerousness for a period of time, but was released. He'd be brought back into court, held again, and then released. Bail was always set at an amount that he could make. It was a nonstop roller coaster of fear and anxiety, and Tia and her family were in fear that he would kill them all. She struggled to understand why her father could not be kept in jail until the trial occurred. As a teenager, she couldn't reconcile that the law didn't really protect her. How can prosecutors be asked to take action when the law does not give them adequate options to keep victims safe? The prosecutor should have had the legal option to appeal the bail at the very least, and at most, push to have her father be held during the entirety of the pending case. Tia's father was able to continue to threaten, harass, and traumatize her and her family because the dangerousness law is flawed. Due to the psychological and emotional harm caused to Tia, she was placed in various treatment programs. She tried to undo the damage that her father caused. She lost her teenage years and did not graduate from high school. Her self-esteem was so low that she began to prostitute and had many abusive relationships. Eventually, though, Tia did realize this was not a life that she wanted for herself, and she broke free from the abuse. In counseling, she came to fully realize that her father's actions were wrong and that none of it was her fault. She struggled to understand how a father could do these things to his own daughter, and often wondered if it was retaliation against her own mother, a way he could continue to punish her for leaving him. Abusers will keep abusing victims because the law allows them to do so. The law needs to change. The impact of sexual crimes on children is traumatic, heartbreaking, and life-lasting. Tia urges legislative leaders to pass the dangerous bill. I thank Tia for providing this impactful statement.
Thank you, Jennifer, and reading Tia's statement. Next, we're going to hear a statement from Jimmy B. The statement is going to be read by Lowney, the Executive Director of the Massachusetts Office of Victim Assistance. Good to see you, Liam.
Good to see you. Thanks for having me here, and it's an honor to lift up Jimmy's voice for this hearing, as I know he couldn't be here today. Governor Baker and Lieutenant Governor Polito, thank you for the opportunity you have given me and my family to share our experience. We hope it will help future victims and survivors of child abuse, domestic violence, and rape. My name is James, and my brother Michael and sisters Valerie and Sienna were placed in foster homes after years of neglect and abuse by our birth parents. We were placed in a foster home with a family that, unbeknownst to us, had already been investigated for abusing prior foster children. We were eventually adopted by the couple. What my siblings and I thought would be our forever home and family quickly became the house of horrors. We all endured years of horrific sexual and physical abuse. Thanks to our brother Michael stepping up and saving us from future abuse, he disclosed what was happening. Our adopted father was arrested, but the judge set a low bail, despite 31 counts of sexual abuse and child pornography. The prosecutor could not appeal the bail, and the child sexual abuse charges were not part of the dangerousness law. It was terrifying for me and my siblings that our adopted father was free to do whatever he wanted while the trial was pending. I ended up in a residential program due to the trauma I suffered. He was able to get a letter to me while I was there, causing me fear and stress that he might be able to find me and cause me further trauma, harm, and abuse. I believe this legislation should pass, especially in cases such as ours where the physical and emotional harm is so great and long-lasting. Survivors should not have to live in fear for the safety of their lives while waiting to go to trial. Survivors need and deserve more protections than the offenders. Again, thank you for the opportunity to share our story and for listening to our support of the dangerousness legislation. Jimmy B.
Thank you, Liam. Now, would call on you to offer a few words from your perspective.
Absolutely. Thank you, District Attorney, and thank you, Governor and Lieutenant Governor and Secretary Reidy. You know, at MOVA, the Mass Office for Victim Assistance, we regularly say, if you want to know how to help victims and survivors, you only have to ask them. And so I want to thank you all for asking the question in all these roundtables. And I want to thank Danielle and Kelsey and all the survivors who've shown up to answer it. This is really an important opportunity to lift up the voices of survivors. Victim rights in Massachusetts and across the Commonwealth requires that victims get information, they have an opportunity to be present, and they have an opportunity to be heard. And we've heard today a lot about the parameters of this law, and I think it's important to state that the Victim and Witness Assistance Board that governs MOVA has endorsed this legislation unanimously. The one provision I want to speak to within it is its role in ensuring that survivors get information about the bail and release of the offenders before they are released. There is no current requirement. And while today in counties across the Commonwealth, there are prosecutors and police departments and sheriff's departments trying to work together to collaboratively make that happen, it's not a requirement. And if we want survivors to be safe, and we really want them to be able to be in control of their own safety, it's essential that we give them the information to be able to make those decisions. And so in addition to all of the other pieces of this bill that others have spoken to, it's really important that we ensure survivor information so that they can make the best decisions for themselves. The criminal legal system depends on victims and survivors. It doesn't work without them. We don't get to the truth, we don't get to justice until we hear from them. And it's just a requirement of all of us in state government to make sure that they're safe while they're waiting for it to conclude. So thank you for the opportunity to be here and for all you're doing.
Thank you, Liam. Appreciate your remarks. Now I'd like to call on Governor Baker and Lieutenant Governor Polito to offer some closing remarks about this very important issue.
Okay, thank you. Thank you very much, Kelsey and Danielle. I want to thank Jimmy and Tia through your voices today for helping us articulate the reasons why these changes need to be made. I want to thank the DA. You very articulately walked through how your office sees these changes and why these tools are needed for you to do an even better job on top of the good job that you do with the resources and tools available to you. Thank you to Secretary Reidy and your team for organizing these meetings. I really appreciate MOVA's endorsement and support, and to all of the members of the commission for coming forward and stating so emphatically why this has to be done on behalf of the survivors and victims and the countless of others who are not visible to us either in the system or through your organization that are depending on us to get this done. You make a very good point about abusers will continue to abuse because the law allows them to do so. And unless these changes are made and abusers and traffickers and perpetrators are held accountable, they will continue to abuse and put people in very vulnerable places. 27 years you have been carrying this burden since a little innocent child. 27 years. I can only say to you today, I hope that your participation in this public forum gives you the strength to know that you're coming forward, you're helping so many others that needed you to have this strength and courage to be here, to explain what happened to you so it doesn't happen to someone else. That is the reason why you came forward, because of what happened to you, so tragic, so painful, so hard. You said, I cannot allow this to happen to another 5-year-old innocent girl. So thank you. I hope this helps you. And the only way we can help you and these countless of others is to make these changes. It's not acceptable that offenses against children, child pornography, rape of a child, human trafficking of children is not an eligible offense just to trigger a hearing to determine if an individual is dangerous. The other piece of this is, if we don't level the playing field, it will be very difficult, as you described, Danielle, for individuals to participate in a system that is already very difficult for vulnerable people to participate in. Going into a courthouse, going into a courtroom, and meeting with strange people that say they want to help you, and then to put yourself in that arena. But even bigger than that, to then leave that courthouse not knowing what the status of your abuser is, or knowing that you only have 89 days left to reorganize and protect yourself and your family, and then wonder what's going to happen on that 91st day, I bet that person's probably more outraged and more dangerous than ever. That never goes away. They don't find in 89 days a way to correct themselves and make them less dangerous. They would be potentially more harmful to you. So the time that you described as a problem in this statute is a significant one. And there are countless other descriptions of why this has to be corrected. So I want to thank you. I want to thank your organizations as well for coming forward today. There's obviously a lot of work to do. I want to thank you for giving so much to this process and for helping us hopefully achieve our goals with the legislative process that is underway.
Let me just add to the gratitude that's already been expressed to you, and you, and you, and you, Mr. District Attorney, for coming forward and talking about something that must be enormously painful and difficult to discuss. The cases that you all were involved in, and that Tia and Jimmy were involved in, have a number attached to them, right? But that's a pretty cold way of describing the people and the life circumstances that are behind it. And I just shudder when I think about what every day of your childhood must have been like, and what most days and many days of your married life must have been like, and what Tia's life must have been like, and Jimmy's life must have been like. They, in some respects, and you represent why some of us got into public service in the first place. It was supposed to be about helping people, and most fundamentally about preserving and protecting those who are least able to defend themselves. And this opportunity that we have to right some terrible wrongs in our existing laws, not based on theory, not based on conjecture, not based on anything other than the real life stories that have been brought forth by these roundtables, is perhaps the best opportunity we have to make the case that nobody's engaged in this discussion because of some predictive model. We're advocating here on behalf of people like you and those that you spoke for, who have life experience that needs to be incorporated into the way we think about how we deal with these issues. And again, I can't tell you how sorry I am that state government let you down. There's no other way to put it. State government let you down. Because we either didn't have the vision or the knowledge to understand what was actually going on day to day to day. Well, nobody can make that claim anymore. It's all out there for everybody to see as pure as day. That unless we do something about this, people will have stories and experiences that can only be described as horrific and tragic here in the state that claims to be so progressive and so interested in protecting those who need their help most. So thank you very much for your presence here today. I'm sure it was difficult. And let's hope we can get something done on this by the end of the legislative session.
Thank you, Governor, Lieutenant Governor, again for being here and continue to advocate for this. It's an important issue for all of us and to you both. And reading the statements, it brings the specifics to light. Unfortunately, you had to go through some terrible things, but I think by coming here and speaking, showing that you're moving forward and making a difference despite the trauma you were involved in. So thank you very much. This concludes our roundtable. Again, want to thank everybody for participating, the governor, lieutenant governor taking the time to come here, our staff, Secretary Reidy, for again dealing with an important issue that requires common sense changes that can benefit victims and society. So thank you very much.
Thank you.
Thank you.
Thank you.
Same thing.
Yeah, you do now, right?
Somebody's hot, especially with